SJC-12298, Benjamin H. Miller v. Joanna Isabella Miller.
Thank you. Good morning.
Good morning. Sorry to keep you waiting.
It was very interesting. Not an area I know a lot about.
Really, whether you can now expand the scope of your practice, perhaps, to aeronautics.
Elaine Epstein for Benjamin Miller. If I can take a moment at the outset just to acknowledge and introduce a couple of people apart from my right this morning, left-hand man, Richard Novich. With me also is attorney Megan Rothmich, who worked on this case extensively before leaving for a maternity leave, now successfully concluded. And also we have an intern here, Madeline Tomasic, who is an undergraduate at Northeastern University, my law school alma mater, hopefully developing perhaps some interest in law. Thank you. There are four troubling aspects of the trial court's rationale and findings here, any of which should require reversal. Those are first the court's pronouncement that General Laws Chapter 208, Section 30, and its requirement of for cause shown for removal of a child does not apply, and that a custody judgment alone determines removal. Second is the court's apparent belief that Massachusetts' loss of jurisdiction over children once they are removed is somehow inconsequential, and the court's misplaced belief that that is remedied by the provisions of the applicable Hague Convention. Thirdly, the court's ignoring an existing order, here a temporary order that had been in place for a couple of years, and the functional arrangements that had been in place for over 3 years, those longstanding custodial arrangements, and treating this as though it were a blank slate that one writes on. And fourth, the court's statements that it is applying the best interest standard, albeit the court seems to arrive there for the wrong reasons, when the decision reads as a classic real advantage analysis and ignores the most important aspects of the best interest calculus.
So if this child had been one where the statute would ordinarily apply to on its face, what's the difference?
I'm sorry, if the statute had applied?
If the statute, the governing statute here as to...
Section 30.
Section 30.
Yeah. If that would have applied, to this child, what's the difference?
Presumably, it's hard to tell here what the ultimate difference is, because the court ultimately got to a place, however, arriving there, that this was she claims a best interest determination. But I think what would have been very different is that the court took this as a case in which I don't have to go through the analysis which starts with the look at what slate am I writing on? What is the existing order? What are the functional arrangements? All of those steps that you go through in a more traditional analysis. It appears that the court viewed it as there is nothing that I have to look at here other than a first-time custody arrangement. And if I give primary custody to mother, then mother can move. And the court also, in a very troubling way, while articulating the best interest standard, at virtually every turn equates that to the real advantage to mother.
Counsel, are you saying that the statute does or does not apply in this case?
We're saying the statute does apply, Section 30.
Even though the...
Even with the part in the statute that says that children who haven't lived here for 5 years or who weren't born here is quite old. It was an 1842 statute. Actually, the provision about children who had lived here for 5 years was not added until 1860. I think when I look back at the history of this, it appears that in those days, back when the Supreme Judicial Court, I might note, also had jurisdiction over all of these issues. The court was held to have continuing jurisdiction over children. So even if the court allowed a child to move to the Wild West at the time and to California, jurisdiction was continuing. So this court could continue to make decisions about that. And in fact, there are some cases listed there's a footnote in Rosenthal versus Maney, it's footnote 11, that goes through some of the old cases. Hersey is of particular note. In 1983, when Massachusetts enacted its own Massachusetts Child Custody Jurisdiction Act, it did not enact the part that gives Massachusetts continuing jurisdiction. So Massachusetts loses jurisdiction 6 months after a child is removed to another jurisdiction, even if one parent remains here. So, and there's kind of an annual ritual here of a bill being introduced every year to correct that. This year it is Senate Bill 806, introduced by Attorney Cream. Perhaps something the court comments on in this case might move that along. But it is of great concern here that once a child is removed, when this child goes to Germany and she's there for 6 months after this appeal is decided, then the German court can decide where the child goes next, and we can do nothing to prevent that. The Hague Convention really doesn't apply. I was somewhat mystified by the judge's comment to that. While the Hague Convention on the international aspects of child abduction does reference rights of access, which would be what I suppose my client has here, although we maintain he really has joint physical custody. But the Hague Convention also has a habitual residence provision, so it's only going to apply if the habitual residence of the child was here for the 6 months prior to the bringing of any action. So it is important here that jurisdiction is lost. It is certainly important, I think, as a general matter also, that this court clarify, if there were any remaining doubt, that Section 30 applies to all children. This court did that in, I believe, 2006, in saying that despite the fact that this statute says that it applies only to the children of divorced parents, that in fact it applies to all non-marital children. That was Smith versus McDonald.
Am I to understand that really the core issue that we have to address is, within the best interest standard, was there an abuse of discretion?
Yes.
And what you're saying is that the judge erroneously applied the advantage to one spouse standard and also the lack of jurisdiction.
Yes, what we're saying is there was the consideration of the weighing of the factors here and the standard used, which was really one standard over another, amounts to an abuse of discretion and in some respects just an error of law.
And where does the GAL report come into that? I assume that a judge can go against the GAL report.
A judge is free to consider the GAL report and is not bound by it, certainly. Here, I think, anytime you have a GAL who spent a lot of time on the case and...
It was 50 some odd pages, it was very extensive.
Exactly. When you have a court, not just, I think, come to a different conclusion, but ignore a lot of the material in that report, that raises a certain level of concern. Certainly in not every instance is a judge bound by that, but here some of those, just the characterization that the GAL found in terms of what the parenting arrangement was, what the facts had been, and the effect on a move. This isn't just a move to Rhode Island or New York. This is a move to Germany, and it's also a child of a young age.
But you didn't raise any erroneous issues of fact, correct, with the judge's finding?
I'm sorry, say that again.
You don't maintain that the judge made an erroneous finding of fact, correct?
I don't think that some of her facts are based, as they should be, on facts that were found by the GAL. I don't think there are facts where I can really say or would say, gee, that was wrong. However, there are some things, such as her saying that there's no order in effect. That is factually wrong. There has been an order and an arrangement in effect, the order for over 2 years, the arrangement in effect for 3 years. But I think
That for a total of 5 years, or are they overlapping?
Excuse me?
Was that for a total of 5 years?
No, it was for a total of about 3+ years.
With some overlap?
Yes, exactly. The temporary arrangement that was informal was in place for a year. The parties then said they will share custody, as follows. And so the total of that was about 3 years. So that's factually incorrect. But I think what is really incorrect here is the weighing of factors, so that
Is that because you think it's you think it's a Mason case, not a Giannis case? I mean,
Correct.
Isn't that what this boils down to? Because if the judge is doing a Giannis analysis, it seems like it's clearly correct, because there's such a huge advantage to the mother of moving to Germany. Her income goes up, everything, she's with her family. So if this is a Mason case, it's a different case. But the judge seems to make findings that the mother has had historic primary custody, right? Findings
She does,
78,
but-
findings 80, you know.
But that's one of the findings that is really unsupported in the record. I mean, not to say there aren't individual facts throughout that would support that, but when you look at the whole, which is, I mean, there are always two aspects to look at. And the court here, I think courts in recent years have moved away from just looking at the label and also looking at what did the people actually do, what they call the functional arrangements. Here you have both the label itself that the parties themselves put on this requires a Mason analysis. It just does. It's shared custody.
Is that her error? I mean, because from what I gather, the husband has custody of the child like 3 out of 7 days. Is that right under that arrangement, or is that wrong?
No, it's right. It's 3 out of 7 days, but many weeks it is 4 out of 7 days. And there are also other times when there's participation in activities, et cetera. So I think there are 2 levels of error there. One is you can't just ignore the label and what did the parties call this, and you also can't ignore what did the parties do for all of this period of time, particularly where you have a child who is then 7, and for 3 years of her life, which is basically most of her recent life, has been in a situation where she's seeing her father 3 or 4 days of every week.
But back to Justice Gaziano's, don't we need to find those facts clearly erroneous, that the mother is the primary custodian of the child? Because the judge makes that despite knowing the arrangement. I'm having trouble understanding how you reverse this unless this is a Mason-type situation. Okay. But she doesn't describe it.
I think it has to do with, number one, the selection of the standard, that if a judge is looking at something from the outset as a Janus primary custody, then it's a completely different weighing of factors. And I think when you look at the findings here, and you also, even if particular findings are correct, if you look at the weighing of those findings, because the weight assigned to different things under these cases can in and of itself be erroneous, then what you see is that everything about the child here, all of the findings have to do with the mother. There is one statement here, unsupported by anything else, in which the court says something like, moving to Germany will be in the child's interest, and I forget the exact wording she uses, but every other finding has to do with mother. And there are some findings where, at best, it's, the factors might be equal. Yes, there are relatives here and there are relatives in Germany, but there's not, just to use that as an example, there's no finding that says, well, why is it more important than why is it more in the best interest of the child that the child be in Germany rather than here? So I do think it rises above just finding that facts are erroneous here.
Can I ask you a simple question, which is, did the mother seek sole custody?
The mother did not, that I'm not remembering now exactly, so
Actually, I
defer to the court
thought she
finding
did.
something additional, but what she did, actually, I believe, is she asked for, and I don't recall if her wording was primary or sole. The court gave her primary. She may have asked for sole, and then she asked to do away with her request for removal. But I believe she took the position that once I have custody, which I am seeking, I can go.
Right, so it wasn't, yeah, so when you said the judge can't ignore the labels of the parties, the mother was basically trying to say,
Right, and the mother was trying to change that label. The parties had already long agreed on a label that was not that.
but they no longer did.
Well, they didn't agree anymore, but they were still following that. It's not like anyone came to the court and said, gee, this isn't working, we should do something different.
Counsel, are you, I read everything, but are you content with the GAL report in terms of to the extent that it looked at the child's psychological position and emotional needs? Was it adequate? Was it thorough enough?
I would have no basis to say, honestly, that it was not adequate. I was not trial counsel. It appears to be a very thorough report. It appears to address the child's needs, and it also addresses that, I say, more correct weighing of the factors, because we have to remember here that it is the judge herself who first said, yes, I am clarifying, this is a best interest determination. So to go back to that question, the judge never said this is a Yanis case. The judge unfortunately got a bit muddled or confused as to which even was the harsher standard.
At some point, the standards do get confusing in that if you say the best interest of the child should always be paramount, regardless of real advantage, but they should always, no matter what.
Yes, and even Yanis requires a look
yes.
at the second step of the best interest of the child.
Okay.
Let's assume you prevail. One of the things which I guess troubled me is how do we sustain the current status into the future? The father does not make enough money to support two households and to support all that the child needs. The mother's rent right now is being paid by the grandmother, who's using her equivalent of the 401k to do it, and that has only a few $1,000s left, so that can't continue. If you prevail, how does this sustain itself?
That's a very tough weighing of different interests, and it probably applies to most removal cases in the Commonwealth. There are few cases where the parties can afford to travel back and forth on one of these bi-coastal arrangements, let alone out of the country. But I don't think that weighs more importantly than the relationship of a young child with a parent.
I understand that, but if the consequence is the mother says, I simply can't afford to live here anymore, I'm going to be living here in poverty, and I have to go back to Germany where I have a good paying job, then it's the mother who has to leave without the child, and now the child's without the mother. Isn't that part of what the judge was considering?
Of course it was part of it. Using that standard, which would always be a real advantage standard, you would never move to the second step, and it would allow any parent who can't find suitable work in Massachusetts, who may have worked somewhere else. There are all kinds of reasons to really, it would almost create a presumption that you can move. The other difficulty here is that courts really, in many instances, have no way of knowing this. I mean, here, you don't have anything in the record that says, I've accepted that job, my employer has said I can start on X date. And so what happens, and this is exacerbated by the loss of jurisdiction, you don't know, and I have no way of bringing to your attention or to the attention of the judge here whether or not the person actually took that job, because I have seen in many cases that that's what in fact happens. The job somehow disappears, and it turns out maybe it was a boyfriend or something else. So I don't think that can rule the day. It's certainly a factor, and I don't mean to minimize people's economic hardship, but most couples in Massachusetts when they divorce, are in exactly those types of economic circumstances, and the fact that there is a better economic future somewhere else can't determine child custody. It's why these cases are really some of the hardest presented to the court.
Counsel, one more question back to the Hague Convention. You said it had no application in this case. Would it have applied had the mother not acquiesced to the authority of the probate court in Massachusetts and just taken the child to Germany? Would they then have had to have returned her?
Yes, it's designed exactly for that. Had the mother just wrongfully removed the child, I suppose there would still be the argument over here about Section 30. So I'm not sure how you'd have to look to the Hague. Under the Hague Convention, you of course decide first which court is going to hear it. Mm-hmm. And that court would then have to determine, I think, does Section 30 apply or not. But certainly the Hague Convention would have, if it was found that Section 30 applied, brought the child back to Massachusetts if it was found to be a wrongful removal. What it does not do is allow us here in Massachusetts to go to Germany and enforce my clients what would then be viewed as rights of access, which is for the child to reside with him for periods of time, which is what's defined as access under it. And that's because, while it's not called home state, which is what we call it here under a jurisdictional basis, but it's instead called habitual residence. And so here, first of all, I've never seen, and I've actually asked other practitioners, I've never seen the Hague Convention used to enforce rights of access. What would happen is, because of the habitual residence, that determination would go to a court in Germany, and Germany would then, because under Hague, the Hague court can't decide the merits of the case, the German court would then likely decide the merits, and that's part of the problem here. The German court can decide, mother goes in and says, this travel is really too tough for the child. We don't know what the standards are in Germany, not that they're not ascertainable, or mother decides, I'm going to move now to Tanzania. I worked there before, that was great. So, and quite honestly, whether or not Tanzania is a signatory to the Hague Convention doesn't give me a lot of concern. It's that you don't know the standard for child custody in all of those cases. So I'm pretty confident that I know if I'm dealing with New York or Alabama, it's going to be a best interest standard. And probably in Germany, it's something very similar. However, a German court can allow a child now to go to another jurisdiction which has one of those more rigid children up to 7 stay with the mother, and beyond that you go with dad, or something entirely different. But even short of that, my client is now at the mercy of traveling to another court. And that's why the interplay of these statutes are difficult. What's really needed here is not only a pronouncement, if there was ever any uncertainty, that Section 30 does apply to these children. And I should say, we as practitioners and the courts in Massachusetts, I pretty uniformly apply it that way. You don't typically see this argument. And then, honestly, the next piece of that is something this court can't do anything about, which is Massachusetts then having a statute under which we have continuing jurisdiction. But given that we don't, that is a factor here.
All right, thank you.
Thank you.
Mr. Burrell, good morning.
Good morning. May it please the court.
Before you start, can you just clear something up for me?
Certainly.
Attorney Epstein said that there was a temporary order in place that the court didn't acknowledge. In fact, the lower court said that there is no existing court order regarding custody. Was there or was there not?
Certainly. I think that's a bit of a red herring. The lower court was clear here that she knew temporary orders were in place. In fact, during the trial, she took judicial notice of those orders. What was really happening and what was really going on was the court was saying that in the eyes of the court, the parties before them in a custody dispute were equal, and that it was her job to determine who should have custody, first and foremost. The issue of the order had to do with the fact that the parties had a temporary order, a parenting plan. But really what the judge did here was she went beyond that. She held the parties equal, and she made a custody determination based upon the best interest in the first and foremost, before she did anything else. And she did that by examining the testimony of the parties and looking beyond the order. Because first of all, the order was, through the testimony, was a 62-38 plan, or 9 nights with mom, 5 with dad. But what was really going on here was, despite the order, father was not availing himself of his parenting time. The findings, which were unchallenged, was that dad had missed a substantial amount of the parenting time, and mom testified at trial. And the
Can I
judge.
ask, before you talk about noncompliance, is a 62-38, 9 and 5 arrangement, is that a Mason case or a Giannis case?
I think that it's a component to that determination. And what I mean by that is that it's not just time, it's actually the functional responsibilities that a parent takes. And it was clear in this matter that mom was the primary custodial parent historically during the pendency of this action, because of the fact that she was the one that arranged all the doctor's appointments. She was the one that arranged all the play dates. She was the one that did the dentist appointments. So when you combine, or in the child's social calendar, when you combine the functional responsibility of the parent with the majority of the time with this child, what you end up with is that mom is the primary custodial parent. And that is a pertinent and unchallenged, uncontroverted fact in this case. And then I think, going back to Justice Budd's question, as to the order was not really followed.
Well, that's fine. Now, what about the removal statute? Do you say it applies?
Well, here's the thing. The judge in this case stated unequivocally that her conclusion would remain the same in favor of wife's removal to Germany, whether she applied the best interest standard or the real advantage, excuse me, the best interest of the child standard or the real advantage standard found within Giannis. So the result ends up the same. But to answer the underlying question, is 208-30 does not apply. I mean, it was discussed in the record in this case. There was a motion regarding which standard should apply by the guardian ad litem. And here, the child is not a native of Massachusetts, has not resided in the Commonwealth for 5 years. So there's an inapplicability to the statute. But I think what makes this judgment so strong is that she addressed specifically, with over 200 findings, best interest, the parenting visions of both parties. Mom disclosed her desire to remove the child to Germany. So the judge had that ability in the first instance to review and examine that parenting arrangement versus the father's parenting arrangement, which was different, which was looking for a Sheard or a Mason. So I think that best interest is first and foremost, and I would submit in this case, where a child is not a native, where a child has not resided in the Commonwealth for 5 years, that's the appropriate, strict interpretation and application of the statute. And I also, going back to the point on Smith v. McDonald.
But just to clarify that then, so when we do this best interest analysis outside of Section 30, do we do a Giannis analysis? You say it's a Giannis case if Section 30 applies, or do we do a pure best interest analysis without putting in that advantage to the mom or the primary custodian that we do in the Giannis cases?
I would answer it this way. I think first you do a best interest analysis.
A pure, because
A pure, I think it starts and ends with the child. I think that is what's the most germane and fundamental aspect of this case, is a judge in the lower court must determine what is best under the individual facts and circumstances of each case, what is best for that child. So you start there. But that's not to say that it would be error for a judge to then look at factors that we find within the Giannis case, to look at what is the best parenting approach, to look at the...
Can I just cut you off a second?
Sure.
Because the judge really does a Giannis. She doesn't do what you just said. She really does a Giannis analysis because it's so focused on the best interest of the mom, isn't it?
Yeah, I think that in this particular case,
I meant
mom was clean and clear that she was looking, that her parenting vision was to remove to Germany. So it's interwoven and inextricably linked to what's in the best interest of the child.
But then that's Giannis. That's not unbalanced. I mean, that's not a pure best interest. That's a Giannis.
Well, I think you have to start with best interest, but what I'm suggesting to the court is that factors that go into whether a parent has a real advantage to move to another state with a child should be determined by a court. The court should examine those factors. I think it's imperative. I think that one factor that goes into best interest in many ways is whether there is whether the custodial parent is looking to deprive the non-custodial parent of parenting time. I think that's an important factor. I think it's an important factor to look at the effect of the new parenting plan if the removal is allowed. And I think our case law has been clear that there are instances where removal is intricately linked to the parenting vision. And I think that's what the judge did here. I think the judge was very clear in multiple findings to go through first what's in the best interest, but also to do the removal analysis and to ultimately conclude that it was in the best interest of this child to go with mom, and that parenting plan in Germany was also within her best interest as well, and that the mom did have a real advantage. Like as Chief Justice Gantz mentioned, mom had an opportunity to earn a job that she couldn't obtain here. That was a strong finding in this case. Mom had a family and friends and felt in Germany, felt isolated here. Zoe, the young girl in this matter, has a close relationship with her grandmother in Germany.
Well, but she also has a really close relationship with her father, and she's not going to after this.
I think it's going to be an effect, but I think the problem there is that, as our courts have held, that if we take the non-custodial, there's an analysis here that in a calculus that when there's a new parenting plan, it's going to affect the non-custodial parent. But if we allowed that to trump all else, there would never be a removal petition. And that's why it comes back to what's best for the child. And in this case, because mom was found to be the primary parent, to be the custodial parent, and to be the parent that would best look out for Zoe's life and Zoe's interests, that in this situation, that trumped it. And, we live in a different world than when Giannis first came to being. We live in a world where travel is more ease. We live in a world where we have Facebook and we have Skype and we have all these methods of communication. And not to say, to your point, that doesn't affect the relationship, but we have avenues available to us now that weren't in place when some of these laws came to being. And so I believe strongly that the analysis should start and end with judges and practitioners with what's best for the child, and that we should look at all these, the totality of the circumstances and the fabric and mosaic of each child's life in each circumstance to determine what is best for that particular child. And I would submit to this court that that's what happened in this matter.
So what do we do with the GAL's report? Because the GAL finds, right, it's in the best interest of the child to have both, basically to stay put, right? I mean, that may not be realistic, but isn't that what the GAL finds?
It is. But the judge has the ability and has the sole right to make that determination. She considered the GAL report. There are factoids in the GAL report that I think are illustrative as to why the judge found what she did. Where the judge differed was the conclusion, and I think when you read that conclusion, it's an inappropriate application of the appropriate standards.
And
I think that was her major problem with the GAL
I
report.
get that, except for if you're right that we do a pure best interest analysis without a Giannis tipping, I'm just wondering if the best reflection of that is what the GAL did.
No, because I think she did the opposite. I think the GAL in this instance basically said, well, it's going to affect dad's rights, forget it. She didn't analyze properly, like the judge in this case did, what was in her best interest. She didn't analyze the parental visions both of these parents offered. She didn't analyze the role as mom had historically and up to this day as the primary custodial parent and that effect. And I think because of that, the GAL report's recommendation was rightfully not adopted by the court, which is certainly in her right to do so.
So does it matter whether Section 30 applies or not? It seems like it's the exact same standard.
I think in this matter, this particular matter, where you don't have a child that meets the requirements of 2830, that it is the best interest standards. And I think what I'm saying is, I think going forward.
And if Section 30 had applied, it would be the best interest
It would be, if Section 30 applied, it would be best interest and then the real advantage standard found within Giannis.
But I mean, the real advantage, isn't that largely focused on identifying the reason why one parent wants to leave the jurisdiction and deprive the other parent of?
It's the first step in the analysis, and then it's a determination.
Right. I mean, certainly if the only purpose for leaving is to deprive the other spouse of the ability to parent, that you're not going to let the person go.
That's correct. And I think that's why it's Giannis is a heightened standard, because you're looking not just at the interest of the child, but you're looking at the interest of the non-custodial parent, the custodial parent, sort of amalgamation of all of these three interests and making a determination as to what's in the best interest of the child. And I think the judge did that in this case, because she did do a Giannis analysis on top of determining who should have custody based upon the best interest. And I think she concluded in either way, in very detailed facts, that it was appropriate to award custody of Zoe to mom, and with that, the ability to move to Germany.
Do you agree with your opposing counsel here that once, if this is allowed, that once the child goes to Germany, Massachusetts has no further jurisdiction?
Yes and no. I mean, we are the one state of 50 that has not enacted the UCCJEA. We do not have continuing exclusive jurisdiction. However, The Hague, which was, I think, taken notice of in this case, I think one of the reasons why the judge stated that was the purpose behind that was The Hague does allow access. And I think that was what the judge's point was there, is that a petition could be brought within The Hague in Germany, that they were a signer to The Hague, and you could, if father had an issue with a deprivation of his parental rights, that he could seek within The Hague. But the custody issue and jurisdiction and concurrent, exclusive jurisdiction, that's, I would say, is for another day. I think that if we were to allow our statute, which differs from other statutes, it would trump the entirety of removal, because anytime somebody sought to remove, they could say, hey, what about this? I think it's actually shows that the judge gave some contemplation to the law and the effect of the removal by indicating that The Hague in Germany was a signer to The Hague. I think that made the integrity of this particular judgment even stronger, rather than she's not moving to the moon where the father wouldn't have any rights, but she was moving to a country that does follow The Hague. And I think that was it was a consideration here.
All right, thank you.
Thank you.